Hello all, and thank you for inviting me here to the Queensland Cosmetic Surgery Information Conference of 2022. I understand many of you have previously had or are intending to undergo cosmetic surgery here in Queensland, and as required, I'm here to discuss the current state of negligence law in relation to personal injury liability in the cosmetic surgery industry, and the elements you will need to prove in order to pursue a claim against a cosmetic surgeon where you have suffered loss in the form of personal injury due to negligence. Australia as a whole spends approximately $1 billion on up to 500,000 separate cosmetic surgeries a year, demonstrating both individual and societal costs. Cosmetic surgery in Australia is not a recognised specialty, and any individual with a basic medical degree can advertise as a cosmetic surgeon, regardless of whether they have specialist qualification or appropriate training. This is still in adherence with the current regulation standards of the national law under the Australian Health Practitioner Regulation Authority, also known as APRA. Recently, there has been an uproar in relation to the under-regulating of the cosmetic industry, which is of growing concern among medical and legal professionals on behalf of clients injured from botched cosmetic surgery procedures. This was exposed by the class action administered by Madden's lawyers against Dr. Lanza and other celebrity cosmetic surgeons who failed in the duty of care to ensure hygienic and safe outcomes for patients. Negligence in the cosmetic industry results in personal injury. This is defined in Schedule 2 of the Civil Liability Act 2003 Queensland as being any fatal, prenatal, psychological or psychiatric injury or disease. I understand some of you have suffered psychological trauma, physical deformities and botched results, all of which constitute personal injury for which claims of negligence can be pursued. In today's discussion, I will demonstrate the duty of care owed by cosmetic surgeons to patients, the importance of establishing the existence of this duty, and the necessity for a breach of duty to have occurred in order to pursue a medical negligence claim. To prove cosmetic liability, you must exhibit the breach of duty on behalf of the cosmetic surgeon was the direct cause of personal injury suffered. I will then list the damages that can be sought and the relevant defenses your cosmetic surgeon could potentially use against you in a negligence claim. I will cover recommendations relating to the necessity for regulation and reform in the cosmetic industry, and negligence liability in Queensland currently favours the needs of doctors as opposed to patients. Therefore, the current state of negligence law in the cosmetic industry does not balance the needs of patients, and reform is necessary to uphold the rule of law. In order to successfully establish a medical negligence claim for cosmetic surgery liability, you must show your cosmetic surgeon owed you a duty of care. There are established duty categories, one being the doctor-patient relationship. A cosmetic surgeon and patient therefore constitute the relationship required to establish the existence of a duty of care. The case of Donahue and Stevenson sets a precedent for a duty of care. A cosmetic surgeon must take reasonable care to avoid acts or omissions which can be reasonably foreseen to injure a patient. As an example, your cosmetic surgeon has the responsibility to provide you as a patient with adequate pre-surgery consultations that provide information on foreseeable risks of an operation and possible outcomes. Cosmetic surgeons have a duty to keep patients safe and provide them with a positive post-surgery outcome. And if you believe there has been a failure in this duty, you may be able to make a cosmetic surgery compensation claim against them. Next, you must then prove there has been a breach of this duty of care owed to you by the cosmetic surgeon. Breaches can occur due to a cosmetic surgeon failing to provide information, a lack of patient aftercare, and improper hygiene in unregulated medical premises. This was demonstrated in the case of Dr. Aronov, who discharged the patient mere hours after the procedure, who then went on to suffer internal and external bleeding as a result of a botched cosmetic surgery procedure and improper aftercare. Chapman and Hurst exhibits a reasonable foreseeability test, which establishes breaches of duty occurs where the surgeon could have foreseen that their act or omission would amount to patient damage. Section 9(1) of the Civil Liability Act requires to prove a breach of duty to take precautions. You must show the risk is foreseeable, not insignificant in the circumstances, and a reasonable person in the position of the cosmetic surgeon would have taken precautions. This is reinforced by Section 21 of the Act, which states a doctor has breached their duty to a patient where they have failed to provide information regarding risk, which a reasonable patient will require to make an informed decision. In 2012, it was found 16% of legal disputes regarding informed consent concerned cosmetic procedures. This is shown in the case of Roger and Whitaker, whereby the court stated the doctor was to exercise reasonable care and skill when treating patients and to adhere to the provision of information. As woman claimed, had she known about the risk associated with the operation, she would refuse the procedure. This constitutes a breach on behalf of the doctor who ought to have known a warning of the risk was material to the patient's decision, and had she known, she would have elected not to have the surgery. The Cosmetic Institute had a class action issued against it in the New South Wales Supreme Court on allegations the company had breached its duty of care to multiple patients, adopting a one-size-fits-all mentality when performing breast augmentations, leading to lung punctures, disfigurements, and seizures. A duty of care exists in this scenario as a defendant has created a risk of injury which arose due to an ongoing relationship between the parties. Therefore, cosmetic surgeon, as a medical practitioner, has a duty to cover all the ways in which they can be called upon to exercise their skill, and where they have failed to do so, you, as a plaintiff, will bear the onus to prove there has been a breach of this duty. You must establish on the balance of probabilities, meaning it is more likely than not that the breach of duty by the cosmetic surgeon directly caused the personal injury suffered. To prove this, you must demonstrate there is factual causation for the harm suffered and that the cosmetic surgeon is liable for this. Section 11, subsection 1A of the Civil Liability Act illustrates it must be shown that but for this breach of duty, the injury would not have occurred. For example, if your cosmetic surgeon fails to warn you, there is a 0.7% chance a major complication following a liposuction procedure, and the consequence of this breach in providing information is you do encounter the rare instance of complication. You have the responsibility to demonstrate that had you been informed of this statistic, you would not have gone through with the surgery, and therefore the omission to provide this information is a direct cause for harm suffered. This is supported by the case of Rosenberg and Percival, which shows where a surgeon has negligently failed to warn the patient must establish they would have responded to the warning in a means to avoid danger. As a reasonable person acts to avoid risk, this should be simple to satisfy. Causation requires proof that but for which the defendant failed to do or has done, the plaintiff's injury would have been reduced or avoided. Therefore, a connection must be evident between the breach of duty and the injury. This is reinforced by Section 11, subsection 3 of the Act, which stresses the importance of considering what the plaintiff would have done if the defendant did not cause the breach, which is to be decided subjectively. You must satisfy to the court you would not have had the operation. Section 11, subsection 1b requires the injury suffered must be within the scope of liability of the surgeon, and Section 11, subsection 4 states to decide the scope, the court will consider whether and why responsibility for the harm should be imposed. Where you are able to satisfy factual causation, it must be established the cosmetic surgeon bears the responsibility of the harm and the extent for which they are responsible. The harm must have occurred under the surgeon's duty of care. There must be no intervening events between the act or omission of the cosmetic surgeon and your injury such that it can be proven the surgeon acted outside of the conduct of the reasonable surgeon, materially contributing to the harm where there is a reasonable expectation that the surgeon would be able to see personal injury as an outcome. If you can successfully prove duty, breach, and causation, you may be awarded damages in the form of compensation, which aims to restore you to your previous position prior to the breach of duty occurring. This represents a fault-based compensation system, as the onus is on you, the patient, to prove the cosmetic surgeon has been negligent by proving all elements, and where this cannot be satisfied, compensation will not occur. Section 50 of the Civil Liability Act states damages for personal injury can be sought for pain and suffering, loss of amenities of life, loss of expectation of life, and disfigurement. Loss of amenities of life will compensate the plaintiff for no longer being able to fully participate in the enjoyment of life, and the patient will be entitled to damages for all the consequences of the injury which are not too remote, with the court taking into account future damages, for example where botched surgery needs to be rectified through second surgery in the future. The cosmetic surgeon will be liable for the full extent of injuries caused by their negligence in adherence with the eggshell skull rule. They will not be liable for inevitable loss due to a pre-existing susceptibility on behalf of the patient. Section 52 of the Act states that unless in special circumstances, punitive, exemplary, or aggravated damages cannot be sought for personal injury. Compensation is awarded if it can be proven the cosmetic surgeon was inexperienced, there was an insufficient preoperative or postoperative planning and communication, incorrect surgical techniques were used, and further surgery was required to fix this or harm was sustained. Cosmetic surgery compensation can be claimed either against the individual or company that performed the procedure, with the amount of compensation received relying on the harm and suffering experienced as a result of the surgeon's negligence. In Queensland, under the Personal Injuries Proceeding Act 2002, you're required to provide written notice of a claim of damages to the cosmetic surgeon, and as this is a medical negligence claim, provide information regarding the procedure and investigative reports where applicable. Disfigurement is an outcome of botched cosmetic surgery, with Australians having to pay to repair sometimes irreversible damage caused by unqualified surgeons. Damages for this will be calculated according to psychological and social impacts on the patient, and providing photographic evidence of the injury enhances the chances of general damages being awarded. It is important to note that with compensation claims, the claim will need to be commenced within 3 years of when you knew or ought to have known you suffered personal injury due to the cosmetic surgeon's negligence. And there is a potential the surgeon could argue to reduce damages for adverse contingencies, which will reduce available restorations for wrongdoing. Where your cosmetic surgeon has offered mitigation and can prove you have failed to mitigate the loss, resulting in a more extensive injury, your damage will be restricted to what the loss would have been if mitigation had occurred. In this scenario, the cosmetic surgeon will bear the onus to prove you unreasonably failed to mitigate. In the current compensation system, cosmetic procedures are not generally covered by insurance providers such as Medicare, resulting in intense out-of-pocket expenses. It is important to consider the defenses your cosmetic surgeon may raise in a cosmetic negligence claim. Under this circumstance, the surgeon will bear the onus of proof to prove the defense. Section 22, subsection 1 of the Civil Liability Act states that there is no breach where the professional acted in a way that is widely accepted by peer professional opinion from a number of respected practitioners in the field, where peer professional opinion is rational. The surgeon may argue that they acted according to the standard of a reasonable professional in their circumstances, excusing liability where the cosmetic surgeon can satisfy this. The cosmetic surgeon must prove what they did or failed to do conformed with the conditions of their practice at the time of negligence. For example, due to complications with anesthesia, it is within the scope of an anesthesiologist as opposed to a cosmetic surgeon to monitor readings, as shown in Gray and Hobson. Contributory negligence can be raised as a defense as cosmetic surgery is a self-elected procedure, and a cosmetic surgeon could argue the patient exposed themselves to a foreseeable risk of injury. The surgeon must prove the patient was at fault and had not acted as would be expected of a reasonable patient, and their own negligence was a factual cause of the loss suffered. Section 23 of the Civil Liability Act states the patient is guilty if they have failed to take precautions against the risk of harm, such as making inquiries regarding risk and procedure. The court will consider what the reasonable patient would have done and what they knew or reasonably ought to have known at the time. If the defendant can show the patient did not seek questions, for example, regarding surgical outcomes and risks, that is not the conduct of a reasonable patient and may satisfy to a degree contributory negligence. If this is satisfied, damages will be reduced to the extent the court believes the patient shared responsibility for their injury, as stated under Section 10 of the Law Reform Act 1995, Queensland. The surgeon can argue voluntary assumption of risk as a defense, where a patient is proven to have knowledge of the risk involved and still freely choose to have the procedure. This is enhanced in situations where an obvious risk under Section 13, subsection 1 of the Act is evident. Where this defense is raised against you in a medical negligence claim, you will bear the onus of proof to demonstrate you were not in fact aware of the existence of the risk. The current state of negligence law for cosmetic surgery does not effectively reprimand the liability of cosmetic surgeons and therefore fails to balance the needs of the patient. Australian states and territories have laws that stipulate the conditions of cosmetic surgery, but do not specify the qualifications required to practice it. Reform is therefore necessary to protect patient rights, and the national regulator, APRA, currently enables dangerous practices by cosmetic surgeons to go unregulated, allowing negligence to continue its cycle. This was shown in the Madden's Lawyers class action, as APRA allowed Dr. Wells to continue to endanger cosmetic surgery patients by continuing surgeries despite evidence of multiple breaches, with APRA only intervening 5 weeks after gaining knowledge of negligent conduct. In September of 2022, the Health Ombudsman made 16 recommendations for reform, including a process under national law that sets out an expectation of minimum qualifications required to perform cosmetic surgery, the implementation of an education campaign to increase community awareness of safety concerns, and the establishment of a cosmetic surgery enforcement unit to take more effective action against breaches of duty in the cosmetic industry. Another necessary reform is requiring an individual who advertises themselves as a cosmetic surgeon to have a minimum of 8 years of study beyond a mere medical degree, which is the current requirement of cosmetic surgeons practicing at the moment in Queensland. The implementation of these reforms will reduce the instances of personal injury in the cosmetic industry, as the standard of care of professionals will be increased, whilst the current law enables underqualified individuals to maim under false pretenses. The current state of negligence law in the cosmetic sector fails to balance the needs of patients, with healthcare regulation favouring the needs of doctors as opposed to patients in cosmetic surgery. To pursue a claim in negligence, you must establish a duty, breach, and causation, and if successful, damages will be awarded in the form of compensation. Defences by cosmetic surgeons of contributory negligence and voluntary assumption of risk may be raised, limiting the ability of the cosmetic patient to pursue a case. Reform will reduce the incidence of negligence in the cosmetic surgery industry, as there will be stricter regulation of cosmetic surgeons where requirements for training qualification are enforced, and cosmetic surgery patients will be more informed of inherent risks. Thank you for taking the time out of your day today to listen, and if you have further questions, do not hesitate to ask.